Hello everybody, it's Janan, lawyer with eLaw Alliance, here once again to provide you legal information. This time, this video is going to cover the topic of the criminal offense of assault. Assault in Canada can take various forms. The less serious version of assault would be covered under Section 266 of the Criminal Code. That would be regarded as a simple assault. More serious assaults, like assault with a weapon or assault causing bodily harm, would be covered under Section 267 of the Criminal Code. And really serious assaults, like an aggravated assault, would be covered under Section 268, and assaults of a sexual nature would be covered under Section 271. These are just some examples of the different types of assaults that exist in the Criminal Code that someone may be charged with. So if you find yourself in the unlucky situation of being accused of or charged with any one of the assaults that I just mentioned, I think you need to keep in mind a few very important things. Namely, if you're being accused of an assault and a police officer shows up at your door or at your work or pulls you over and wants to discuss with you the allegation, please be mindful that you have the right to remain silent. This right to remain silent isn't reserved for just guilty people. No, this is a right that applies to all citizens in Canada. And the purpose of this right to remain silent is to ensure people aren't forced to give statements, and that if they do give statements, it has to be voluntary, with an understanding that they don't have to provide the statement and that they're allowed to contact a lawyer before they provide a statement. Often, I tell clients who have been charged with a criminal offense, such as an assault, to exercise their right to remain silent. The reason I tell clients this is because if you're going to talk to police and provide your version of events, you may inadvertently in that process say something incriminating that the police can then use against you. Or you might say something that can be twisted, misinterpreted. The prosecutor might use your statement to police, and if she finds or he finds an inconsistency when you're at trial testifying, they're going to capitalize on that inconsistency, throw it in your face and say, hey, you're not consistent, maybe you're not credible, maybe you're lying, in order to try to attack any potential defense you have or your version of events. So to preserve your narrative, to preserve your story, often I'll tell clients, don't tell the police your version of events. Save your version of events for where it really matters, which is in front of a judge at your trial. The judge will determine if your story has credibility or merit. The judge will determine if you are guilty or not guilty, not the police, not the prosecutor. So for that reason, I often tell clients to exercise the right to remain silent, preserve their narrative for trial, so that it gives them the best shot at a defense and the best shot at a finding of not guilty. So if you've been charged with an offense, and now you've already, with an assault offense, and you've exercised your right to remain silent, eventually the police officers will provide you with a court date. If they've decided to charge you, they'll then provide you with a court date. Make sure you take note of that court date and don't miss it. If you hire a lawyer, the lawyer will attend court for you to deal with the preliminary matters. We usually describe that as docket court appearances. These are court appearances where the lawyer shows up, adjourns the matter for a week or so or more in order to get disclosure, in order to get client instructions, in order to talk to the prosecutor about a possible resolution. So these are docket court appearances. The types of court appearances that are more substantive would be trial or summary disposition or guilty pleas. Eventually, not right away, but eventually you'll have to decide whether you're going to plead not guilty and set your matter down for trial, or plead guilty and proceed to summary disposition or sentencing. Before you decide to make any plea, a good idea is to have your lawyer or yourself review your disclosure. Your disclosure is going to contain all of the allegations made against you. It'll contain witness reports, if there are any, complainant reports, if there are any, video statements, audio recorded statements, written statements, notes from the police officers. These are all part of a disclosure. You're entitled to it, and you're going to want to review it before you enter a plea. Certainly as a lawyer, I wouldn't enter a plea on behalf of a client until I've read that disclosure so that I can figure out whether this is going to head in the direction of trial or head in the direction of a summary disposition or a guilty plea. There is technically a third option instead of trial and a guilty plea. The third option is more of an alternative method of resolution. It's not afforded to the most serious offenses, so you're not going to be afforded leniency for a very serious offense like an aggravated assault or some assaults with a weapon or assault causing bodily harm. In some situations, prosecutors are agreeable to resolving an assault by way of something we call a peace bond. A peace bond is a way to resolve a matter where you don't end up with a criminal conviction on your record. Instead, what happens is, if it's something that the prosecutor is willing to entertain, the assault itself will be withdrawn and replaced with a peace bond instead. So that's how it will be reflected in your record, not as a conviction, but as a peace bond, which is different than a conviction. With a peace bond, you would be legally allowed to tell an employer, if they ask you, do you have a criminal record, that you don't have a criminal record if all that happened was a resolution by way of a peace bond. What is a peace bond? Basically, it's a promise to the court that you are going to minimally keep the peace and be of good behavior for a period of time. Usually the peace bonds last anywhere between 12 to 18 months. So you got a promise to keep the peace and be of good behavior, and the prosecutor and the defense lawyer might also include other conditions in the peace bond, such as a no contact order, a area restriction, requirement for treatment such as anger management or domestic violence counseling. These are conditions that could be included in a peace bond. And a peace bond's not so lenient when you consider that if you breach the peace bond, you could be charged with a criminal offense, breach, and then find yourself right back in the criminal justice system. And it'll be much harder to argue for something like a peace bond or a more lenient sentence if you just keep coming back to court doing the same thing. So that's what a peace bond is. It's not provided in all circumstances of assaults. In my experience, it's normally reserved for the less serious matters. I've never seen a peace bond granted for more serious offenses. So if you've got unrelated record or no record and the assault you've been accused of is not very serious, you might be open to having your matter resolved by way of a peace bond. If you have a lawyer, the lawyer will canvass that potential resolution with the Crown, the prosecutor. But if you don't have a lawyer, then it's on you to contact the prosecutor to see if a peace bond is something the prosecutor is open to doing in the circumstances, or open to resolving in that fashion. Now, keep in mind, if you hire a lawyer, the lawyer is going to go to court for you to ensure that no court dates are missed. If you don't have a lawyer, the responsibility is on you to get to court to make sure you don't miss any court dates. Why is it important not to miss a court date? Well, because you could be charged with a failure to appear. Nobody wants to be charged with a failure to appear. Nobody wants to have to deal with an additional charge on top of the substantive one. So go to court or hire a lawyer to go to court for you. Now I want to talk briefly about the conditions that go into a peace bond, or the conditions that follow if you're released on bail or an undertaking after being charged with an assault. Often, prosecutors or justices of the peace will require that the accused person have no contact, direct or indirect, with the complainant. These no contact conditions are very common. They'll prevent you from talking to the complainant or being around the complainant. A lot of people get caught in breaching or get caught breaching these types of conditions because they don't realize the extent of it. Some people might say, I didn't talk to her directly, I talked to her mother, I just wanted to send her a message. That would be considered indirect contact and could open the door for you to be charged with breaching the no contact condition. So be very mindful that if you're charged with an assault and there's a no contact order in place, that no contact order means you're not to have any contact with the individual directly or indirectly, meaning through other people. Now, part of the process is also going to mean eventually you're going to order a copy of your disclosure. Why is it important to order a copy of your disclosure? What is disclosure? I'll tell you. Whatever the complainant has accused you of, whatever the police say you did, you're going to be entitled to know the details of it. So you're going to be entitled to receive police reports, police narratives, the complainant's statement, any witnesses, any video surveillance, whatever the case against you is, whatever evidence they say they have against you, you are entitled as an accused person to a copy of all of that evidence. If you have a lawyer, your lawyer will order it for you. If you don't have a lawyer, you got to order it directly in court from the prosecutor. You'll very much want to review your disclosure because that's going to tell you what, if any, potential defenses you might have, what, if any, potential mistakes the complainant might have made in her statement or the police might have made in their investigation. Only by reviewing disclosure are you going to find out potential defenses. They might exist after reading the disclosure. Even if there isn't a blatant defense in your disclosure, after talking to your lawyer or giving your version of events, there may very well be a defense just in your version of events. Now, as I said previously, eventually you're going to have to decide, am I pleading guilty to this? Am I pleading not guilty to this? Or am I going to resolve it in another fashion? If you decide to plead not guilty, a trial date will be selected. Trials are usually anywhere from 4 to 12 months down the road is when they're normally booked. And at trial, the complainant must attend, normally has to attend, and give the evidence that he or she gave that justify the charges in the first place. That complainant is going to be subject to cross-examination by your defense lawyer. So your defense lawyer is going to get the opportunity to test the complainant's version of events, to try to shake that version of events, to try to uncover potential defenses. Now, after speaking to your lawyer, you may have to yourself take the stand to give your evidence. Normally, lawyers don't routinely put their clients on the stand to testify, but sometimes they do. And sometimes you are, in a sense, forced to give your version of events. Otherwise, if all the court is left with is the complainant's version, and there's something that calls on you to give your version, often you might be required to do that at trial in front of a judge under oath. And you will be subject to cross-examination, but the cross-examination isn't going to come from your own lawyer, it's going to come from the Crown prosecutor. So if you decide trial, we've talked about that. If you've decided a guilty plea, sometimes what you can do with a guilty plea is just work out a deal with the prosecutor. Maybe it's a deal for jail time, maybe it's a deal for probation, maybe it's a deal for a fine. Maybe you and the prosecutor don't even make a deal. Perhaps the sentencing is contested, meaning the prosecutor is going to pitch what he or she thinks your sentence is going to be, and your defense lawyer or you will pitch what you think your sentence should be. And then the judge makes the decision at the end of the day. Sometimes to assist in the process of reaching a sentencing decision, it might be helpful to get a pre-sentence report where the court will have someone reach out to you to do a very comprehensive interview with you and some collaterals to find out your background, your remorse level, your supports in the community, that sort of thing. A very more detailed, in-depth investigation into who you are as a person. And then that report is provided to the court, hopefully to assist you in getting the most lenient sentence. But sometimes those reports are not very favorable, and it could lead to a harsher sentence if the pre-sentence report is negative. So I've sort of summed up the laws with respect to assault. I think the most important thing to remember with an assault is try to resist the temptation to give your version of events to police. Instead, preserve your narrative, or at least talk to a lawyer before you decide to talk to the police. And the lawyer can give you, in the moment, more definitive advice with regards to whether you should give a statement or not. Often the best course of action is to exercise your right to remain silent, preserve your narrative so that your lawyer can deal with it in court. So there it is, folks. If you're charged with an assault, be very mindful of court dates, no contact conditions, and start deciding on how you want to resolve the matter. Trial, guilty plea, or maybe another fashion, possibly like a peace bond. That's it for this video. I will be putting out more videos on criminal law, so stay tuned. Hope you like this video, and until the next time.